Please, Lordship, I'm just praying for moving one unlisted civil revision. Since I'm a station council, Lordship, can it be possible today, Lordship? I filed it now. So after all the matters are over, then can it be possible to take up? Civil revision petition, Lordship. I filed one civil revision today. Since I'm an outstation council, Lordship, so can it be possible to take up the matter today? I filed it now, Lordship. After all the matters are over, Lordship, then the Lordship pleases to take up this matter.
Can it be allowed or it has to be mentioned?
As unlisted, Lordship.
Can be allowed by this. Okay, let us see after.
All right.
May I please, Your Lordship?
Yes.
I beg to mention item 24.
Item
24. Due to non-appearance of the respondents, I was appointed as an amicus in this case.
Yes.
Just few days back. But I have seen the records. They have challenged the discharge order, but the charge sheet itself has not been annexed. Only few parts, so it's difficult.
Record was not called for?
No, record was also not called for. So therefore, records may be called for. The case is now transferred to JMFC Namsai. After the charges of 302 and others were dropped, for the smaller offenses, it was transferred to JMFC Namsai, and it is GR case number 71 of 22. So at least even if they don't annex, if the records are called for, then it'll be easier.
Without records, how matter can be taken up and be heard? This was discharged by a session judge?
Yes.
So
Some offenses, they were discharged of some offenses.
which of the offense is triable by a session?
302.
302 is also, yes.
Yes, 302 is also there.
Okay.
Then
Record need to be called for. If the record.
now, since this bigger offenses they were discharged from these bigger offenses, for the smaller offenses, the matter was transferred to JMFC Namsai. It is now
from the offense?
From offenses under section 120B, 452, 353, and 302 IPC.
Okay.
But
thereafter it was transmitted to?
JMFC Namsai.
JMFC.
Yes.
Okay, now the record
Now-
is with the JMFC.
Yes, it should be in the JMFC. Yes.
Okay.
Although we're not concerned with the rest of the trial, but
Okay.
at least the charge sheet.
Who is for the petitioner?
Yes, my lord.
By the state?
By the state, my lord, SIT, my lord.
Mr.
El Kurdu, my lord.
Elkudu.
SPP, SIT.
Planet. SP.
SPP, SIT.
ACPPS. Who is present? Miss N. Dange. Planet Amicus. Ready for the
Respondents 1 to 6.
for all the respondents.
Yes.
Is also present. Huh? It is submitted that the petitioner has not annexed all the required documents, and the record has also not been called for. Whereas the record would be necessary for proper adjudication of the criminal petition. So in view of the above, let the record be called for from
JMFC Namsai.
Judicial Magistrate First Class Namsai. What is the number?
GR case number 71
Record of the GR case, GR number 71
of 22.
of 2022. Be called for from the Planet Court of Judicial Magistrate First Class Namsai. Okay. list this matter after 3 weeks.
No, my lord,
No,
fixed date, my lord,
it-
18th,
Hmm?
18th of next month, my lord.
Scan copy, it can be called 18, we can.
18th,
Record. Okay, then a scan copy.
Yes, scan copy.
Okay, let scan copy of the record. Of GL case. Okay.
Matter may be taken up on 18, Lord.
18th.
18.
Yes, my lord.
18 of August.
Oh,
Yes.
18th of August.
Okay. Case paid for by the land council for the parties. Let this matter be listed on 18 August. Okay.
Oblige.
May I, my lord?
Yes.
I beg to mention item number 17. My lord,
Yes.
my lord, the TCR has not, the TCR is yet to become. Your Honor, this-
Just wait. This is in order. Let us see the record first. Okay. We'll pass necessary order.
But
Okay. In order, no need to mention because we have to see the record. Thereafter, only order can be passed. No mention. Order.
Lordship, item number 4. I've already taken the consent from the other side.
Why? This is motion.
Yeah, this is in motion.
It was already moved earlier.
Yes,
Okay.
Lordship, or earlier occasion also, they adjourned the matter, Lordship.
We'll see. Only for adjournment, if you file, it will be difficult. Let us see. You file and without moving adjournment. Let us see. What?
Hi, Your Lordship.
Hmm.
I wish to mention item number 2, Your Lordship. The leading counsel, C. Modi, is, Your Lordship, out of station.
This is also motion.
Yes. The leading counsel is out of station, so
Why
maybe
then you have filed?
due to some urgency, Your Lordship, he has to went somewhere, Your Lordship. So just
Wait,
pass
when?
over for tomorrow, Your Lordship.
Tomorrow?
Yes.
Okay.
Oblige.
You are miss
Tirimi.
on the prayer of Miss Tiring, land council for the petitioner. Let this matter be listed tomorrow.
May I allow your Lordship? Lordship, I'm praying for listing of a matter which was on 31st. It's a pending matter,
Hmm?
criminal petition. I'm praying for listing of a matter.
Okay. Where is the mention memo? You have
Yes.
there.
Yes,
When do you want?
31st of this month.
31st.
Yes, your Lordship.
Why?
Your Lordship, the urgency is that this year was called for on the last date and it was supposed to be filed, it was supposed to be listed after 2 weeks. And 2 weeks has already passed and the urgency is that
No date was fixed.
no date was fixed.
Okay.
I've checked in with the registry, the TCR has been received from the JMFC.
2 weeks already over.
Yes, your Lordship.
Okay.
Obliged, your Lordship.
Ma'am, this criminal revision petition has been prepared by the CBI against the impugned bail or the common bail or the matter. And the Lordship will find the impugned bail or the page number the 129 page annexure 8, by which in the both the accused person has been allowed to go on bail without giving an opportunity to the petitioner to make objections and this bail has been granted only within a period of 2 days from the date of arrest and the arrest was these 2 accused persons were arrested on 23rd July 2025 in connections to the CBI case number so and so and subsequently the next date of when the accused persons was produced before the landed special court, there was an order for the judicial police remand for only 1 day, and on the next day, it was again produced. On which day, again the order was passed for remanded for the judicial custody. On the same day, without giving an opportunity, without calling CD, without any other basing on another.
Nobody represented the CBI.
CBI were represented, ma'am.
Were present otherwise.
Yes, ma'am. Counsel for the CBI were also present, ma'am.
Okay.
The seriousness of the case is
Made prayer for calling of the case diary.
yes,
Whether the
no,
CBI
there was no order for the even case diary.
No, whether the CBI, the council has made prayer for calling of the case diary.
Yes, ma'am.
It was not called for.
Not,
The
not.
first day after arrest, they to the police custody,
Yes, madam.
and immediately on the next
Madam,
day.
first remand is lordship will find at, in my petition, madam, I have enclosed. It is only police custody for 1 day, madam. And it was again reproduced on 25th, madam, and on which 14 days judicial custody was given, madam.
That one, which is the first order, have you annexed?
Yes, ma'am. Yes, ma'am. Lordship will find at annexure. Annexure 3, page number 41, madam. 41 year. Case number so and so, madam.
41.
Yes, madam.
This
4-1.
This is the first production.
First remand order, madam. Lordship will find at para 6, next page, page.
They were arrested on 23rd.
Correct, ma'am.
That isn't recorded. I have made a prayer.
Yes, madam. This is one of the, madam, the serious case. Last, second page, madam, page
Yes.
number 42.
Police custody for only 1 day.
Yes, madam, that is the book, madam.
So at the time of production, I must have,
Madam,
Made a
made
prayer.
prayer.
how many days it was? He prayed, and I have prayed.
Madam, 14 days judicial custody, madam.
14
I
days.
was sought for the-
Judicial or judicial custody?
Yes, ma'am. Sorry, police custody for 14 days, ma'am. That has not been taken into consideration. Only 1 day police custody has been given. And the next remand, madam, I'll skip the ground of arrest and other things, so many grounds, madam. How the recovery and other memorandum of recovery.
Okay,
sheet.
the annexure 4 is the,
Annexure 4 is the,
no, no,
madam.
no, where is the forwarding of the accused and with the prayer for remanding of 14 days?
Madam, I'm sure that is not, madam, enclosed, madam.
Not enclosed.
Yes, ma'am. It is in the case record, ma'am. That has been already produced before the Malad London special judgment. The next remand order is at page number Malad 52, annexure 5,
Hmm.
page number 52, madam.
Okay.
Next remand order, ma'am.
But investigation, they submitted that investigation is almost completed.
No, ma'am.
It says that the father accused custodial remand of the accused is not necessary. It's a submission of the IO. Then, see,
Madam, this is
para 2,
para 3, madam.
they read para 2.
Para 2, the inspector so and so appear along with the land counsel for the CBI MS so and so landed, remand advocate Sri so and so is also present.
Hmm.
Though the prayer for the 3 days police custody is made in the permitting letter submitted by
Yeah.
IO through the learned special through PPCY. The learned PP as well as the IO of the case submitted the process of the investigations with regards to the accused person is almost completed.
Hmm.
With
And further.
further accused custody is not required. This is
See?
completely not correct.
Now you are making allegation against the presiding officer.
In any case, madam, in a single day, madam, everything cannot be, madam. Madam, may kindly, madam, taken into consideration. On, madam, this is the difficulty, madam. On 23rd, madam, the accused persons was very
Maybe, but you see the
But,
submission.
madam, in a period of, madam, 24 hours, madam, the
I have
investigation.
no idea.
This is the, madam,
No idea, but then it's your submission.
Yes, madam.
See, if you submit
This
like
is
this,
wrong observation, madam.
it's not observation, it's a recording of the submission of the line PP and IO.
But we never submitted, madam. On 23rd, accused
And it's
persons.
para 3 also.
Yes, madam.
Recording
The IO
statement, voice
submitted that,
sample.
madam, IO
Everything
submitted
completed.
that custodial interrogations of the above accused persons have been done, including, madam, the recording of the specific. Statement has been done, madam. Recording has been done. Their statement, madam. And as per their statement, madam, Nexus is again, madam, based at Mumbai, madam. If again that, madam, the company who is based at Mumbai has to be also investigated, madam. Madam, admit to the fair to make fair submission, madam.
Given
that
that
extent-
submission, it's possible. It's your submission.
Yeah.
Okay, anyhow, we will issue notice then. We'll have to issue notice, but then this is, if this is your submission, then you see the presiding judge also had no reason to disbelieve the submission of the line of PP as well as the IO.
In that case, madam, I'll come with my barrier, madam, that other part, madam. Madam, in any case, madam, the investigation cannot be, madam, taken, madam, completed, madam. Only interrogation, madam, to that extent.
That is why I'm saying,
Yes, madam.
where
And
is
I
the
appreciate
forward,
your-
where is the forwarding,
Madam.
where you have stated those, and you have not annexed that also. Okay. Or Mr. M. Carter, land counsel for the petitioner.
The temporary short notice may be issued in the meantime, madam, since it is cancellation of the pay
Yes, yes, sir.
on 5th, madam. A week time is sufficient to, madam, cause service to the petition, other accused person. And this was, madam, moved as bail application was moved as unlisted motion item, madam. On the
This is
same
an-
day.
This is an application. So the Central Bureau of Investigation filed this application from the Deputy Inspector General of Police. No, Central Bureau of Investigation through the Deputy Inspector General of Police has filed this application under section 442 of the Bharatiya Nagarik Suraksha Sanhita 2023. Seeking cancellation of the common bail order dated 25/7/2025 passed by the London Special Session, Special Judge PCA, within bracket PCA, UPA. In bail application number 350/2025 in connection with CBI case number RC 0172025 capital A 008/2025 under section 61 within bracket 2 of the Bharatiya Mia Sanita, 2023, read with section 7/8/9/10/12 of the Prevention of Corruption Act 1988. Start. Record need to be called for.
My lord. Record will be recorded.
Okay.
Our prayer, my lord.
Call for the scan copy of the record. Huh?
And my lord, along with the CD, my lord.
Hmm?
CD, my lord.
Okay, as well as the case diary.
CD of the, from the CBI, my lord.
Issue notice to the respondent. To show the as to why the bail granted to them on 25/7/2025 shall not be cancelled. Is grateful. Start. The petitioner shall take steps upon the respondents by a registered post with AD within 2 weeks, 2 days
2 days, my lord.
from today. List this matter
Short notice may be given, my lord. On
Hmm?
5th, my lord.
on 5th.
My lord.
This is matter on 5th.
My lord.
Yes.
May I please proceed? Proceed, this is a regular bail application. Filed in connection 14 of 25 under section 21A, 27A of MDPS Act. Read with section 328/3 of VX. Proceed here, so my only.
Yes, you have filed bail application earlier.
Yes, earlier it was,
Before the trial court, then thereafter before the high court. And then thereafter again before the trial court, and now here. What is this?
proceed.
Your bail application has been rejected time and again,
Yes,
3 times. This is subsequent, huh?
proceed. When the approach before the Honorable High Court, during pendency of that bail application, the charge sheet was filed. So accordingly, but the filing of charge sheet, the ground for filing of charge sheet was not taken on that day. Thereafter, it was,
Even after filing of charge sheet also, you have filed,
yes, approach before the trial court.
okay.
Yes.
That has
He
been
didn't
rejected.
consider, but the ground of rejection was saying that lordship, before till examination of main witnesses in the case, because lordship trial has already been commenced. And next,
Trial already comment.
yes, lordship,
Okay, that means the charge frame under the same section.
charge is yet not framed here. Fixed method is,
Charge not yet framed.
yes,
Then how the trial began?
cognizance has taken,
Okay,
and next date is fixed on 19 August 2025 for
for
appearance,
examination of the,
yes, appearance of the accused person.
okay, copy you have received.
Yes, copy I have received. Thereafter, lordship, it was, bail application was heard,
Hmm.
and it was rejected with many grounds, but one of the ground is, Your Honor, that the till examination of main witnesses,
Hmm.
the bail cannot be considered. Because in total, there are 20 prosecution witness, the statement of the prosecution witness has been recorded.
Hmm.
So, Your Honor, my ground would be, because it will take long time for examination of all those witnesses. And they are simply mentioning the examination of main witnesses. But there is no any certainty how long it will take and who is the main witnesses. That is, I'm not challenging the bail order, lordship, not appeal, but it's still, Your Honor,
When it was bail overruled?
Page number 57, lordship.
it was-
Second paragraph, lordship.
Page
57, lordship.
57.
See, you have filed 57.
57.
See, day before yesterday, last week only. Last week or this week? Last week. See, you are filing bail application one after another successively 4 times. Every time rejected, and probably the bail by this court also rejected on the ground that you have not taken any new ground. Your bail was rejected by the trial court. This court rejected, and then again trial court. See, filing successive bail application for release under the in such cases doesn't mean that you acquire right by filing successive bail
Yes,
bail
absolutely.
application one after another.
Absolutely, Your Honor.
And give some space to breathe also to the court and the investigation agency also. You see, immediately next week it was rejected, no new ground.
But yes, sir, of course,
So
that
because why the court reject? Even there is a less region also, but then court think that he doesn't deserve now at this stage, That is why they reject.
Yes.
The court reject. And then you say, you are filing one after another within a month, four bail application.
Yes.
See, this, of course, now this is filing the charge sheet.
Yes, this is now.
Before
this is-
filing the charge sheet, you have,
This
before
is,
filing, you have filed 2 bail application, disturbing the IO also to submit all those. See, this is code. Certain issue, somewhere you also have to realize and instruct your client also that successive bail application doesn't do filing successive bail application, it doesn't acquire any right. It will aggravate.
Yes, that is there. In fact,
Yes.
their bail, after filing of charge, of
Hmm.
course, their counsel, they ought to have withdrawn, but they approached before this court
See.
again with us. But right now, Your Honor, my respectful submission is, Your Honor, since after comments,
He has the observation, he is a prime drug peddler operating Alo and the Pasigat. He is the main one. The observation you must have seen.
yes, I have got.
And then he has attempted, he threw away those substances also in the river when he saw the police. You see, this destroyed the evidences. Deliberately, you see, like that. Quantity the heroin and mobile also to
Yes.
destroy the evidences. See,
As
his
per-
conduct, you see, his conduct, and subsequently after arrest also conduct one after another bail application desperately, and then he has no earning sources, but he has so many things. This shows so many things. Court would not like to immediately take some rest, give some space to the court also, and the investigation agency also. And an observation you see later on, it has in earlier bail application, it was not made any observation, but now you see there is an observation. He is involved in the POCSO Act also. He is accused in the POCSO Act also. Have you seen?
Yes, I have seen.
See, so
But-
many negative things are coming against him.
Yes, yes.
Only because of his
Allegation-
conduct.
Allegation.
That is what I'm saying. So as a human being, although the trial court or whosoever may be judged, but they are human being. Conduct of the people who are bad, they understand at least. So that way, one or other reason they will find out to reject the bail because of the conduct of the accusing himself.
No.
And now you see, ultimately he observed that under the circumstances, examination of the main witness. Now, can we change? We can change, but then let the situation change. You just make an attempt before the trial court at the time of hearing on the question of charge. After framing of charge, then at least some steps. Charge already framed, some witness already recorded. So no need to wait for the examination of all the material witnesses. That could be the good ground, isn't it? But then no, now you see, no, nothing has changed.
Now, Lordship, here is a effects court saying that the accused also need to prepare his defense. So pendency of trial, it is not possible for the accused person to prepare his defense while in the custody.
Yes,
So-
that is there.
Yes, so during pendency of this, only that point, Your Lordship, today again I approach. Because now the Lamet Trial Court, they while rejecting my bail application, they made a specific averments mentioning that only after examination of main
And he's
witness,
preparing well, it appears, by engaging as advocate like you.
only mentioning that after examination of main witnesses before the court. So,
That,
Your Honor,
that may not be, of course, the
Yes,
ground for
there are
rejection, huh?
total-
That may not be, huh?
yes.
But then,
So, Your
but then
Lordship-
immediately now, anyway,
Yes, Lordship, I may be heard and call for the DCR.
now you see, again, we have to call for the record. Record and nothing has changed. Yes. On the same ground, the bail was rejected. How do we reappreciate all those? And then this entire thing have to be repeated while rejecting your bail. And I have to add something also. See,
Lordship, in the rejection order also, there is no ground, Lordship. Successive, they did not file bail application on new ground.
that
Lordship.
is,
Yeah.
now, so his conduct, the evidence is considering entire thing. So the bail was rejected. Anyway, you still want the record to be called for?
Yes.
The same court who has rejected the bail will try the case.
There is a change in circumstances, Your Honor. In fact, earlier counsel, they ought to have withdrawn after filing charges, but instead of
Yes, yes.
withdrawn, they,
Okay.
without making any new ground. So,
Mr. Indra.
yeah, Lola.
Yes, for K. Lole, land counsel for the petition. The petitioner filed this bail application under section 483 of BNSS 2023 for granting bail to the arrested accused. The Doji, who has been arrested, and the accused, who has been arrested by Alo police in connection with Alo PS case number 14, 2025 under section 31A, 27A, 27 capital A. Earlier small within bracket A, now it's 27 capital A stroke 29 of NDPS Act read with 328 stroke 3 within bracket 5 bracket close BNS 2023. Call for the scanned copy of the case record,
DCR.
trial court record, trial
Yes.
court record. Mr. Loy, Lanet PP appeared and accept notice on behalf of the state. Okay. List this matter again on. Just after 2 weeks, Lordship. After 2 weeks. Okay.
This matter, Lordship, might remember, Lordship, the illegal arm possession, Lordship. The
Illegal?
son surrendered the arm before the eye, Lordship.
Okay, this is son surrender. Here in this case.
Yes. This is regular bail application, Lordship. Earlier, that was a pre-arrest bail.
Item 4.
Yes, Lordship.
Item 4 is criminal petition, not bail application.
Extreme sorry. Oh, sorry, I was. Oh, yes, Lordship, I'm sorry, Lordship.
You want to withdraw this case?
No, Lordship.
Then we'll issue notice.
Lordship, next that kindly
Okay.
be given.
What can? As, as prayed for by Miss Dirilo. List this matter next week. Okay.
Lordship, after 3 weeks, Lordship.
After 3 weeks?
Yes, Lordship.
Okay, after 3 weeks.
That was Lordship.
Yes.
So this is joint petition for quashing of the FIR.
Okay.
What's the quashing of?
FIR.
Yes.
So, my lord,
Joint petition.
This,
Joint petition.
Your Lordship, this item will be deciding factor of this item number 10, 9, 8, 9, 10, the bail application also. Because your Lordship,
Item 5 is
Yes.
connected with
8, 9, 10, my lord, anticipatory bail.
8 and 9 also.
8, 9,
Eight,
10.
nine. Three bills are there.
Hmm?
Three numbers.
8, 9 and 10.
Yes, your Lordship.
These are anticipatory bill. It's
Yes,
connected to this case.
Yes, directly connected with this case. Now they are come with an agreement of settlement deed, my lord.
Oh,
So once this is allowed, the 3 will goes.
the picture is clear, it appears.
Lordship, in this connection, I have decision of the apex court recent of this year only, where previous hurt is involved. FIR. Entire case is very similar. Paragraph 4.
But it says,
Paragraph 4. Lordship. Subsequently, the applicant petitioner has filed a present miscellaneous application seeking relief for compounding the offence under section 320 IPC based on a compromise reached between the parties after a dismissal of the special petition. The applicant petitioner states that all the disputes between the applicant petitioner family and the complainant's family have been amicably resolved with the intervention of the elders and villagers. The applicant petitioner has agreed to pay such and such as total compensation to the complainant as part of the settlement. The complainant has filed its IA number such and such for implementing in support of the petitioner's prayer for compounding the offence, affirming the compromise, and seeking closure for the matter to ensure peace and harmony between the parties. The complainant and the petitioner reside in close proximity with only a road separating their houses, making essence to maintain a peaceful relationship between the two families. Here, Lordship, here the petitioner and the complainants are the clan sisters with same surnames. They are clan sisters with same surname. All are Nablam.
clan sisters,
Yes,
the accused and the victim.
complainant.
Okay.
Further, the parties are also distantly related, and any lingering hostility is likely to disturb the social fabric of their neighborhood. The compromise covers not only the criminal case, but also related property disputes, including the right of way, which had been a point of contention for years. The applicant's commitment to paying the agreed compensation reflects a genuine effort to end the discord and uphold the terms of the settlement. Needs that the complainant's unequivocal support for the compromise further underscores the voluntary nature of the settlement and the shared desire to put an end to all disputes. Accordingly, this was quashed.
Can you just see once what is the settlement?
Yes, settlement is at page number 20. 20.
Page
20.
20. What is this additional affidavit?
Lordship, there was a minor also. Minor, a named accused was minor. So her father has entered into a settlement deed. Page number 20. See all the name. The complainant is number 1. Accused number.
Okay, the party number, first party is the
Complainant.
okay. Informant.
And others are accused persons, named accused.
And then the second party is, yes, it appears the surname is same.
Yes.
So this second party is the main accused.
Yes, second party is the main accused. Actually, what happened, Lordship, the complainant was having an affair with the husband of the main accused. So it was scuffle between the sisters.
The attack should have been to husband only.
Yes, in the very next page, page number 21, Lordship, kindly see whereas such and such husband of one of the second parties
with such and such, and the first party were having extramarital affairs for about 15 months. It is pertinent to mention here that Srimati such and such had been persistently approaching the first party not to indulge in affairs with her husband. However, the first party and the husband of Srimati such and such continued their affairs despite entering into an agreement dated such and such. Eventually, all these culminated into a heated commotion and minor scuffle between the first party and the second parties without any actus reus or mens rea. So therefore, Lordship, the conditions are here. There are 1, 2, 3, 4, 5, 6 conditions are there, and they have settled the matter amicably.
Any compensation?
No, no compensation, Lordship.
No compensation.
No. She did not ask any. So because they are sisters eventually.
If it is connected, what is your submission?
Yes, my lord, here the statement in the AB matter, your lordship, we have received the case diary, your lordship. Their statement is duly recorded, and there, your lordship, the victim has admitted that she has a relationship with the husband of the
Victim.
accused person. Yes, your lordship.
Okay, the first party.
The complainant, your lordship,
Okay.
the Miss Baby Nabla. She has admitted that she has an affair with the husband of the accused, your lordship.
This is one.
And earlier also, your lordship, she was advised by his wife, the first wife, the not first wife. Now they are proposed to get married according to their settlement, your lordship.
Okay, now this is the second wife.
Yes, your lordship. The first wife is consented with their relationship, the husband and this complainant, my lord.
Now this is compensation for the case.
Yes, your lordship. Perhaps your lordship, my lord, perhaps, and your lordship, the custom also, your lordship, permit the second marriage also. So I can make submission on that.
I was just worried about if she has been threatened to withdraw.
Yes, your
Threatened to
lordship.
enter into or settle or
Yes, your
execute.
Yes,
If that is sure, then
That condition has to be, your lordship, recorded. The condition under which they have entered into for your lordship, for
do we need to confirm? Do we need to confirm from the informant?
Your lordship, if suppose, your lordship, supposedly, if either of them has given any false statement before this court, if any case or anything come up,
That is why.
then this court can initiate case against them, your lordship, because it is on oath, my lord. On affidavit, they have approached this court, your lordship, and their agreement is also there. Earlier also, your lordship, they appeared this court, but on the motion stage, your lordship, we have made the initial objection that one of the co-accused is a minor. And since it is well settled also, your lordship, the minor cannot be shown an affidavit or not.
Yes.
So, considering the facts and circumstances of this case, this honorable court has orally directed them to file an affidavit, your lordship, on behalf of the minor by the parent or the relative, your lordship. For that they have filed, and this is for the second time before this honorable court. So now, your lordship, the question here is, your lordship, this dispute, otherwise if we say, is emanate from the marital dispute. That is, yes, your lordship, because in Lakshmi Narayan case, it says, if it's a marital dispute, it doesn't say the sections or the offense. It says if it emanates from the marital dispute, and when the party has entirely settled the dispute among themselves, then the court has a power to quash the matter under section 482 or the corresponding section 528. So here, your lordship, even from the statement of the victim itself, it is very clear. She says she has this is your lordship.
Police statement.
Yes, your lordship. Here, your lordship, the investigation in summary is there. The examination of witness has been done, wherein the victim was reportedly in personal relationship with the Deni Lambu, husband of the main accused. And the main accused has assaulted the victim. She has, your lordship, cut her hair, your lordship, by teeth only, your lordship, not by the weapon. However, your lordship, the injury is shown as a grievous injury. Now, even for the grievous injury, your lordship, the Lakshmi Narayan case comes again, from where it has emanated.
326. Okay.
Yes, your lordship. And second part is the judgment which my learned senior counsel has, brother has relied on, H.N. Pandekar matter. There also, your lordship, 326 section has been compounded, but after conviction, the post-conviction. But that same matter has been referred before the coordinate bench, where in the pending matter also the expect has been taken into consideration, because it will be otherwise, if the matter will be allowed to proceed further, it will be amounting to abuse of process, considering the fact and circumstances of the case. So here also, your lordship, if we see from the face of this case, even the FIR, your lordship, if we say that there is something was there, that's why they have assaulted the complainant.
So now what we can do at the moment, because this is in the motion stage.
Yes, your lordship.
So what we can do is, if this can be confirmed from the victim,
Yes, your lordship.
that if she has consented
Yes,
for
your
the withdrawal. So if if he doesn't have any objection, so that confirmation can be done.
Yes, your lordship. For that, to that effect, your lordship, perhaps they have annexed an agreement, my lord.
The agreement is there.
Yes,
but
sir.
then
To confirm that, your
agreement
lordship.
is
Yes,
signed.
your lordship.
He has already entered into settlement twice with minor also.
Otherwise, your lordship, for confirmation, your lordship, she may be allowed to appear through RBC also, or personal appearance also, the victim, before this honorable court. For confirmation, my lord. Other.
Inspection of the
Yes, yes, your lordship.
special PP, additional PP and the court will just, because there it is connected with all these cases. Means they are protected also.
Yes, they are protected, my lord.
Okay, so that also will have to be made absolute.
Yes, your lordship.
So,
If your lordship, if there is an stay in this criminal petition, then automatically this case will become infructuous. The AVs,
Applications, bail applications.
anticipatory bails.
okay, that will become infructuous.
Yes, your lordship, because there is no any requirement of protection, since if it is the main
Yes,
interest
yes.
is state.
Yes.
So my humble, your lordship, suggestion would be, for the time being, your lordship, till next step, for the appearance of the victim, this matter, the
Lordship.
further proceeding may be state.
Lordship, it can be done at 2 p.m.
Yes, fine, your lordship, convenient.
Sure, tomorrow.
Yeah, tomorrow, your lordship.
So this is in the motion stage.
Yes, your lordship.
Let it be in the motion
So,
stage.
if there is any other material, you can.
Yes, your lordship.
Okay.
Lord,
Mr.
let it be in the motion stage only.
Okay. Mr. K. Saxena, Land Council for the petition. Sorry, this is a joint petition filed by the informant and accused persons. In Itanagar Police Station case number 88, 2025, under section 61, within bracket 2, stroke 126, within bracket 2, stroke 118, within bracket 2 of Bharatiya Nyaya Sanhita 2023. Oh. Quashing of the FIR. Quashing of FIR only.
Yes.
Okay. This is when this was filed, not yet filed charge sheet.
No, madam. Charge sheet not filed.
It was in the month of May, way back in the May. It's been.
Your lordship, the issue here is, your lordship, if it is on merit, my lord, then your lordship, the Nyarika case would come. But if it is on, your lordship, on settlement, your lordship, then court can, it well within its jurisdiction to exercise.
FIR dated 24/5/2025. registered as Itanagar Police Station case number 88/2025. Under section same. Huh? So there is a record you have already produced.
Record, yes, your lordship,
You have
I have the
received
record.
This is updated.
Yes, your lordship, I have the record. Their statement is, since statement has been recorded, your lordship.
Okay.
No new things.
Mr. Theatre, done additional PP. Some stats. Since the some is that the accused in the above PS case has filed rearrest and it will be bail before this court in connection in which case the case tariff has been called for. The case tariff has been produced to the staff. However,
Or your lordship, without staying the proceeding, your lordship may fix the matter day after tomorrow along with the bail. Then would be better, my lord.
8, 9, 10. Okay.
Along with the 8, 9, there is no any requirement of interim order
praise-
also.
And praise for listing this matter along with the bail application.
8, 9, 10. 85, 87, and
Along with
90.
the AB 85, 2025,
87,
87,
90.
2025, and 90, 2025. Prayer now, list this matter.
My lord, let it be day after, my lord. I'm not feeling well, so your lordship, day after tomorrow.
Okay. As prayed for, list this matter on 31st July,
31st,
31st.
yes. And my lord, informant victim may be directed to,
On which date? Where is the number 1? The updated case tariff shall be produced. And the informant victim shall also be present before this court in person.
yes.
Okay.
In person, was it through
Or,
RBC?
or in person
Or through RBC?
or through.
RBC.
With necessary I-card, your lordship. With required I-card.
Okay.
I-card will be required, your lordship,
Yes,
to ascertain the identity
with I-card. Okay.
of license.
Your Lordship, this matter may be passed over for the time being.
Okay.
It may be taken up as last matter.
Okay.
Deeply obliged.
Possible for the time being.
Yes, Your Lordship.
Okay. Item 5. No?
May I please, Lordship?
Yes.
7 and 11 may be taken up together, then
7 and
11, it's same PS. And CD was called for.
Lordship, just now I received the status report, incomplete city, Lordship. Only 2 pages status report, Lordship.
incomplete.
Yes, Lordship.
In that case, Lordship,
Why incomplete?
Scan copy was called for, Lordship, but only status report.
This is bail here.
bail matter, Lordship.
How long the accused has been arrested? What is the offense involved? UN.
Yes, Lordship, if status report is not there, then proper CD may be called on 19, Lordship. It will take proper hearing, Lordship, because
Accused are involved in, Lordship, extorting money from the.
Okay, that is the one which you have, we are referring to. the Procedural surrender of arms.
No.
It's from
This is from Londing case, Wakka case.
Wakka Lordship,
Wakka case, Londing.
Consta Lordship. Longding.
Both the alleged accused
FIR is at Lordship, page number 14, Lordship.
So what do you want?
Says Lordship. See,
You want a complete case diary? with
yes,
what?
Lordship. Yes, Lordship.
Yes.
For education, Lordship.
Okay. Mr. Uttam Bori, Lana counsel for the petitioner is present. Mr. Lana PP submits that although he has although he has communicated this court order, however, the investigating agency has not forwarded the complete complete set of the case diary. This is what actually.
It's status report, Lordship.
Okay. Therefore, pray for some more time.
Yes, Lordship.
When?
Lordship, maybe on 19.
Okay.
Yes.
Okay.
August.
On the prayer is allowed. Please pray for Kama. Let this matter be listed on 19 for bail hearing. Okay.
Highly obtained.
These along with 7 and 11.
Item 11.
11 of
Same order.
same order. 7 and 11.
Mayor Lordship. Lordship, this is a bail application. Here, Lordship, I'll click straight away to the FIR.
Also, okay. Yes.
The FIR, Lordship. It's page 13.
Here also the case diary was called for. It
Case
appeared-
diary was called for.
Lordship, this matter may be kindly pass over for a while, Lordship.
Hmm?
Pass over for a while, Lordship.
For the time being.
For time being, Lordship.
Okay.
Obliged.
Lordship, I'm on the behalf of the Das Bolram Das and the petitioner.
You're on behalf of
Bolram Das, B Das.
for the appellant.
Yes, Lord.
You want adjournment?
No, not adjournment, this, list, for the mediation in the next, because, this, we have already filed the affidavit.
Okay, who is for the other
Others.
side?
Other side is, Marga Doji and Toktem Tai. Not present.
Okay, you're for.
Lordship,
We'll send it to the mediation then.
senior was instructed me to take adjournment board. He is at Alo.
Okay, we'll send it for, you appear before the mediation,
Yeah.
mediator,
In- in-
okay,
Yes.
okay. Miss D. Reno. Hard Miss D. Reno, Land Council, appearing on behalf of Mr. Boluram Das, Land Council for the appellant. I've also heard Mr. Your good name?
B. Sibo.
Hmm?
B. Sibo.
You are appearing on behalf of
T time, Dr.
V. Sibo, appearing on behalf of Mr. T. Time, Land Council for the respondent. Respondent is for insurance company or private?
Insurance company.
Insurance.
Yes. I'm appearing for respondent number 3.
Respondent number 3.
Yes, Lordship.
So respondent number 3, New India Assurance Company. Sir. It is submitted. Okay.
Lordship, notice maybe issue on the respondent number 1 and 2.
Not yet issued.
Yes.
Then how it can be sent? It is, challenge is regarding what? Against the insurance company only, or whether this respondent number 1 and 2 is also necessary for the purpose of disposal? The challenge is regarding what? Quantum or what? Kindly assist the court properly. It's a dismissal of the restoration petition only, along with the delay condemnation for non-appearance. Then how this can be sent to the mediation? Kindly obtain proper instruction from your client, because this regarding only restoration of the petition. Petition probably was not yet disposed of, or for the dismissal of the condemnation petition also for non-appearance. So there is nothing to be decided by the, nothing to be immediate. You obtain proper instruction from your client.
Lordship, in page 28, it's already mentioned here in para 1.
Page 28.
28. Affidavit.
There is no
in
page
affidavit.
28.
In affidavit. Lordship. In affidavit.
Yes, this is certificate. You have taken steps.
No, we have submitted that affidavit number.
Yes, it's a compliant
06.
affidavit.
Yeah, 06.
Then the after presence, the appellant has taken steps upon the respondent number 1 and 2 for newspaper publication and file affidavit after the publication of the newspaper in Arunachal Front. And also annex the original paper publication. In the Arunachal Front on 27/7/2025. In view of the above, the notice upon the respondent number 1 and 2 is complete. However, no one appears on behalf of respondent number 1 and 2. This is matter. This appeal is for what? You come prepared. You have to come prepared. Counsel, you have to assist the court properly.
Yes, no proof.
You list this matter after 3 weeks. Next time you come prepared, it cannot be sent. Because this is regarding the dismissal of your condemnation petition. Okay.
May I please, my lord? Hello, this matter picks for admission hearing on 26 August, my lord, and one learned senior counsel, Mr. R.P. Sharma, will appear in the matter, my lord.
This matter to be listed?
My lord, 26th of August, my lord.
26th of August.
Yes, my lord. Admission hearing, my lord.
To be listed on 26th.
Yes, my lord. 26th August for admission hearing, my lord.
Meantime, Lordship.
What parties are represented?
Yes, my lord. No, my lord, I have taken consent from the private respondent.
Who?
Mr. T. Tapu.
Okay. Hard Mr. N. Ram. Then counsel for the petitioner. Also, Miss L. Haji, then additional EP for the state of AP. Mr. Rama submit that. Whether record was called for here in this case? Okay.
Last opinion, Lordship, also a call for the scan copy of the case study, Lordship.
Hmm?
Scan copy of the case study,
Yes,
Lordship.
the scanned copy of the case study has been received. Since the party are duly represented and the scanned copy and the record has also been received, let this matter be listed for admission after 3 weeks. Okay.
Lord, on 26th.
On 26th.
Yes, my lord. 26th August, my lord.
August, okay.
As learned senior counsel has directed.
Let this matter be listed
Requested me to.
for admission. Staff, is prayed for listed on 26th August.
My lord. Much obliged.
This is 14-15. Okay. Yes.
May I please, Lordship?
Yes.
Lordship, this matter may be listed after 2 weeks, Lordship. Lordship, here, Mr. Tijamo, Lordship, leading counsel, is having some unavoidable personal difficulties, Lordship.
Okay, this is criminal petition.
Lordship.
You have received the record. Let us see. Just a minute. Okay. Hard, Mr.
Ketabang, Lordship.
Direct counsel, the petitioner. Your name is there? No.
Lordship, there's my
Your
name
name
is
is
there.
there. Okay. The file of record has also been received. Who represents?
And Lordship, meantime, there is an interim prayer, Lordship.
Yes,
Maybe continue, Lordship.
Who represents the state here?
there is your lordship, they have been directed to file affidavit, your lordship, for respective petitioner, and they have filed it. By the way,
Joint application.
yes, my lord. But their statement has not been supported by the affidavit by some of the petitioners. So they were directed by this honorable court to file affidavit. So I have received the copy, your lordship.
Okay, they have already filed.
Yes, your lordship.
Okay. Okay, Mr. Priya, then additional PP is present. So, since the parties are represented, no, this. So then we'll list it for admission.
Yes, your lordship.
Okay. Parties are duly represented and the record has also been received. Then the matter will be listed for admission after 3 weeks.
Lordship, interim is there. It may be
Then the matter will be listed for after 3 weeks for admission. Stop. Para. The interim order pass earlier shall continue till the next date of listing. Okay.
Maybe obliged. Obliged.
My lord.
Yes.
On the last occasion, TCR was called for.
What happened on the last occasion?
TCR was called for.
It's this case that it appears. Whether case has been charge sheeted?
Yes.
Why case diary was called for? You have received case diary or trial court record? You know, the case diary was called for last time.
Yes.
PCR along with the case diary was called for.
Is it?
Yes, your lordship. Your lordship will find in the order dated 3/7/25. Charge sheet is already annexed, your lordship, in page 23 to.
Okay, already charge sheeted.
Yes, your lordship.
Then case diary not required.
Yes, your lordship.
It is not
TCR
available.
is required.
It will be TCR only.
Yes, sir. TCR not received.
You are Mr. Titagro. Titagro, Land Counsel for the petitioner is present. Mr. T is there. Land additional PP for the state is also present. The trial court record. It is called for the case diary. Okay. As per the record, call for the case diary. We'll call for the TCR then.
Actually, yes, your lordship. Actually, on that day, your lordship, perhaps it has not been recorded, but the court has given a direction for TCR as well as the charge.
No, it is called for the case diary only.
Yes. Then your lordship, TCR, because matter has been charged sheet.
Mr. Okay, Mr. T. there, additional petition, Mr. Case has already, since the case has already been charge sheeted. The trial court record may be called for. Stop. Putting a call for the trial court record. List this matter. Again after.
My lord, on 12 September.
Okay. Take break for command. This is matter again on 12 September.
Yes.
12/9/2025. Okay.
Much of it.
So we'll send it to, can we send it for the, before the mediation?
Yes, ma'am.
Yes. Okay. Hard, Mr.
Yes.
You're for the respondent?
Yes, ma'am.
You're for the appellant. Mr.
B. Sibo, on behalf of Standing Council of
Mr. B. Sibo.
T time.
An advocate appearing on behalf of Mr. T. Time, Land Counsel for the appellant. Also had Mr.
The other one.
Diado, Land Counsel for the. Your respondent number?
No, I'm the sole respondent, ma'am.
Sole respondent?
Yes.
How it is sole respondent in the MSC case, MA appeal?
And for all the respondents. For all the respondents.
See, 3 respondents.
Yes, ma'am.
Appearing on behalf of all the respondents. Start. both the non-council parties agreed and consented for the mediation of the case. So accordingly, let this matter be sent to the sent for mediation to the registry shall take necessary steps for placing the matter before the special mediation drive. Yes, mediation for the nation. After giving notice to the parties. Okay. Okay.
Mashallah.
18 and 19, that is.
Lordship, in this case, T Tang has instructed me to take adjournment.
No, this will be sent for the mediation, before the mediation. But we try to settle through mediation. Okay, there is a mediation drive. A special mediation drive will be conducted. I don't know when, but then they'll issue notice. Okay, we'll send it once.
Yes.
If it's unsuccessful, it will come back to here. Timing. Okay, then hardness. This is 20 and 21.
Item number 20.
20.
20.
20.
Okay, only 20. Okay. You are appearing on behalf of BR Das.
B does.
BR Das. Okay, appearing on behalf of Mr. BR Das, Land Council for the appellant, and Mr.
B. Sibo, appearing behalf of T
appearing
Tang.
on behalf of Mr. T Time for all the respondent again.
Respondent.
Therefore, respondent number.
Yeah. Steering Council of New Indian Assurance Company.
Okay, for the respondent number 1. Stop. On the consent of the parties, let this matter be placed before the special mediation trial. There's mediation for the nation. Stop the registry shall do the needful for placing the matter before the special mediation trial by issuing necessary issuing notice to the parties. Okay. Okay. This also will try to place it before. This is old method. Petition. Yes.
Yes, Lordship, we are willing to
Go for
this
mediation.
matter to be referred to mediation.
Just a minute. This is on merit or what? Okay, negotiable sum, okay. Mr.
A Gamre.
Land counsel for the petitioner. And Ms.
Tirimi.
Rimi, land counsel appearing on behalf of the respondent, sole respondent staff. On the consent of both the land counsel for the parties, let this matter be placed before the ensuing special mediation drive. There's mediation for the nation. Stop. The registry shall take steps for placing the matter before the special mediation drive by issuing notice to both the parties. Okay.
Also, this is a criminal petition. On previous date, TCR was called. Already charged the matter.
Why it has been listed for this? Can it also be placed before the special mediation drive? Because these are the matters.
Yes,
Suggested for placing before the mediation drive.
That will be better.
Is it on merit?
No, Your Lordship, this is on settlement, man.
Settlement has been done.
Settlement.
Yes, Your Lordship.
So joint petition or?
Yes, this is joint petition also.
Joint petition.
Yes, Your Lordship. This is not required for mediation. My Lord, mediation is required when the parties has not settled.
Yes.
If they have settled.
Lordship, I have annexed.
This is joint petition.
Yes, Lordship.
I have then in that case, what is the office involved here in this case?
392, my Lord. 392.
92.
Yes, my Lord. 392 is robbery. Robbery, yes. Punishment for not robbery, man. Sorry, I'm sorry. 448. Yes. 427. 323.34.
Trespass.
Yes, trespass and your also injury.
No, it's 448. Yes, 437.
Punishment for
324.
trespass.
Okay.
Trespass is compoundable, my Lord.
Yes,
427, mischief causing damage is compoundable. 323 is, I think, is also.
324.
And the other one is 323.
323 also there.
Yes, my Lord.
I could see only 324.
Also, initially the case was registered and charged under 324.
Okay. Initially, Your Lordship, it was registered under.
Okay. Case
All were compoundable earlier, but now after filing of the charge sheet, 324 has been inserted, and 324 is non-compoundable.
Non-compoundable.
Yes.
Now, the party has amicably settled.
Yes, Lordship.
Where do we see? Where do we find the settlement agreement?
Lordship, kindly come to the.
Just a minute. Whether after filing of charges, whether the case has been charge framed or not yet? Whether the charge has been framed?
Yes,
against the
Lordship,
accused
charge has been framed.
Under 323.
Yes, Lordship.
Have you annexed
Yes,
or is it on record?
Lordship, I have annexed the.
Frame charge under section. Your Lordship, if charge is framed under 323, then Your Lordship, it is not maintainable, Your Lordship. They have to approach the concerned court by way of proper appropriate application for compounding of the same.
Is 23 compoundable?
Yes, my Lord. Section 323 says compoundable by the person to whom the hurt is caused. Initially, it was registered under 448, 427, 323, 34, but charge sheeted under 448, 427.
Where is the order?
Your Lordship will find in page 49.
Yes. 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 447, 427, 320, all are compoundable with it. And it can be compounded by the trial court.
They ought to have filed this application changing the cost title before the concerned magistrate, madam, for compounding of the same.
Yes. You make appropriate application before the trial court because both the parties are.
Under invoking 320, Your Lordship, or the corresponding section.
320 CRPC.
Yes, or corresponding section of BNS.
Parties are ready.
Your Lordship, in that case, Your Lordship, they may be directed to appear before the concerned court with the appropriate application, Your Lordship.
See, could have actually pointed out earlier before this court, if it is a compoundable, advocate should have seen. Have you not seen?
Your Lordship, we were not aware of it earlier, Your Lordship.
So it was the section they probably has filed as per this. It's 320. 323 here also. Okay, heard Mr.
P. Bate.
Dana counsel for the petitioner. Also heard Mr. Ete, Dana additional PP for a state of AP staff. But this is a joint petition filed by the petitioners under section 528 of Bharatiya Nagarik Suraksha Sanhita 2023, praying for quashing and setting aside. This for compounding only, it should have been. You have not mentioned GR case?
What's about mention?
Where's the GR case number?
GR number, Your Lordship, RNGR 260. 260 of 2019. Your Lordship, in the cost title, page number 2.
Yeah, RNG registration 260. What is this RNGR?
Also, in trial court, it's easily written RNG.
I have no idea.
Yes,
Normally, we know it's here. Okay.
Yes,
Praying for. Okay. Quashing and setting aside of the proceeding of GR number 260 stroke 2019. Arising out of Sangram Police Station case number 17/2018 under section 448 427, 323, 34 IPC. Start. Para. At this stage, Mr. Redbeck, the additional people pointed out that all the offense registered against accused applicants are compoundable offense. Therefore, the same can be compounded. Compounded
My lord,
by the person to whom the heart is closed.
in addition to that, my lord, even the charger frame under the same sections.
Yes, that is right.
Yes.
And the person to whom the loss or damage is caused. Start. The Land Council for the petitioner has considered the submission of the land petition of people. So in view of the above, the petitioner is directed to file appropriate application before the trial court for compounding of the case under 320 of the CRPC. On such application being made, come the learned trial court shall pass necessary order in accordance with the law. Okay?
Yes, Your Lordship.
Start with the above, please. Criminal petition stands disposed of. Then
My lord, maybe
the scan copy.
yes, my lord, this matter may be dismissed on Your Lordship, being non-maintainable, Your Lordship.
Okay.
Because this is 482, 528, Your Lordship. Inherent power has been invoked.
Okay.
But the revenue is there under 320.
Of the above, this matter is then that
Yes.
direction will be withdrawn.
Yes, Your Lordship.
This matter in view of the above, this criminal petition. Is not maintainable. No?
Yes, Your Lordship.
Accordingly, this criminal petition is dismissed. Okay.
Yes.
Much of us.
Return the trial TRC.
Yes, sir.
As trial court record, TCR. Okay.
Obliged, Your Lordship.
Any trip? Yeah.
May I please, Your Lordship?
Yes.
Your Lordship, this is a joint criminal petition, Your Lordship, on the basis of amicable settlement, Your Lordship. The informant and the accused, they have come together by filing an application under section 528 of BNSS, Your Lordship, for quashing and setting aside of charge sheet number so-and-so, corresponding to Inkyong PS case number so-and-so, registered under GR case number so-and-so, under section 447, 426, 5110, 290 of IPC, Your Lordship. Your Lordship, the offense 290 is for punishment for public nuisance, Your Lordship. And then public nuisance, Your Lordship, which is punishment fine of rupees 100. And then section
426 is non-compoundable.
No, Your Lordship, 426 is compoundable.
Oh,
it is for
which one is not compound?
290 and 5110, Your Lordship. It is
What is 5110?
5110 is
510.
oh 510 is for misconduct in public by a drunken person, Your Lordship. So
It's not non-compoundable.
yes, two of the section, it's not compoundable, Your Lordship. So Lordship, FIR, it's at page number 24, Your Lordship. Annexer 1, Your Lordship. May I read the FIR, Your Lordship?
Yes.
Okay. To the OCPS, OC Inkyong police station, and if I'll just read with the relevant portion, Your Lordship. I am to submit the following unpleasant incident that took place at the casualty department of district hospital, Inkyong, that on dated so and so at around 11 p.m. 3 boys in drunken state, one of them laden with a local dog, burst into the casualty department, fumbling the EMO room and refrigerator, medicine and injection cabinet, seemingly looking for something. On being inquired by emergency staff, they pretended visiting some admitted patients in the indoor, however failed to name the purportedly admitted patients. Whereas there was no admitted patient in the indoor department except one cancer patient who has nothing to do with the miscreant. While leaving the casualty...
Thereafter charge sheet filed.
Yes,
Case
Your
investigated.
Yes, Your Lordship, charge sheet has been filed on dated 26/02/2020.
Charge sheet under which section?
Same, Your Lordship, same section.
Same.
Yes, same section. Now the case.
Where do we find the charge sheet?
Yes, Your Lordship.
Where do we find the charge sheet?
Oh, charge sheet is page number 25, Your Lordship. 25 to 66. Annexer 2, Your Lordship. 25.
25 to
25 to
39.
66. Yes, Your Lordship.
66.
Yes. Starting from 25, Your Lordship.
Charge sheet against so and so. How many accused person?
Accused, 3 accused are there, Your Lordship.
Yes, same section.
Yes, Your Lordship, however, the actual fact...
Whether the charge framed before the court, trial court?
No, Your Lordship, it is in... No, Your Lordship, charge has not been framed.
Cognizance taken?
Yes, cognizance has been taken, but then...
Where do we find the order?
I have not enclosed it since, Your Lordship, interim was granted after taking cognizance of the case. I have filed this joint petition and then interim was granted, Your Lordship. So, Lordship, the fact, although like the FIR, it's the fact, actual fact is different, Your Lordship. On the day of incident, the 3 accused, they had a long day at the paddy field, and then they went to their friend house and then had some drinks there. And then one of the accused, he started complaining of stomach ache, Your Lordship. And then accordingly, they went to the since it was late at night and all the pharmacies, it was closed. So, and when they were in the hospital, they look out for the nurse or the staff, but then they couldn't find anyone. So one of the...
Thereafter, the case was settled between the parties.
Yes, Your Lordship.
Where do we find?
Page number 66, Your Lordship. Your Lordship, the offense is very... It is just public nuisance, Your Lordship. And even on many occasions, Your Lordship, this same bench exercising the power, inherent power under 528, Your Lordship, has quashed.
Okay, Dr. Teng.
Yes, 67, Your Lordship. Annexer 3, Your Lordship. May I read the settlement agreement, Your Lordship?
Okay, just let us see. See the page 68. Okay, yes. Yes, Lordship, I have gone through the nurse who present in the at the time of incident, Lordship, also Lordship. So not no, it just Lordship, they are entered with drunken states only, Lordship. Page number 46, Lordship. The statement of the nurse, Lordship. Page 46, Lordship. May I read? My details are given above. I work as a nurse in the district hospital Yingkyong on dated so I was detailed as the night duty nurse. I, along with Miss Munangao and Anu Ifar, were sitting at the nursing room since there was no patients in the casualty room. At around 11:30 p.m., a vague sound was heard and three men came inside the casualty room. We thought that they were present, but they did not call us. We got frightened and waited for a while. One of them opened the fridge and their intention was seemed to be not good. Then I came out from the nursing room to ask them their purpose of visit. Two of them ran away and the last one was standing in front of me with a machete. I asked him what happened. He replied me that they were visiting their patient who had been admitted in the. Then I asked him to ward number and the name of the patient to the author. So he forgot the ward number and patient, and then he apologized for the mischief and went out. And according to Lordship, they settled their dispute by entering agreement, Lordship, as an extra Lordship. So.
Your Lordship, no harm were caused, and then it was unintentionally, Your Lordship. And they are young boys, Your Lordship, in their mid-20s, Your Lordship. They have a long future ahead, Your Lordship. So, continuing of this petition, it will cause a lasting mental trauma, Your Lordship. So, for the interest of...
Yes, Lordship. Heart miss. Heart miss.
8 alum, Your Lordship.
Actually, this is I think 23. You are K?
8 alum, Your Lordship. Emit alum. Yes.
Land council for the petition. I also had Mr. Land PP for the state of Arunachal Pradesh. Staff. This is a joint application file under section 528 of Bharatiya Nagrik Suraksha Sanhita 2023 for quashing and setting aside the proceeding in GR case number proceeding of GR case number 45/2023 under section 447 428 510 290 of the Indian Penal Code. Arising the Indian Penal Code arising out of Yingkyong PS case number 26/2023 under section GR case arising number so arising out of Yingkyong PS case number. Here the section will come under section. Okay. There are three accused.
Yes.
The petitioner number Dr. Karol Pen is the informant, and the petitioner number 3 Jamin Lipir, petitioner number 3 Tanong Taga, and the petitioner number 4 Takit Dalong are the accused in the above GR case. Okay, I'll dictate it. Okay.
Yes.
How many meters? 2 meters. Yes. Disposal. Yes. item 6.
May I please, my lord?
Yeah.
My lord, the order under challenge is at page number 77. Last page. My lord, in this application, we are challenging the impugned order. Impugned order dated 26/8/2024.
Just a minute. Page
77.
77 is there.
At the second last page of my petition.
Impugned order.
Yes.
Let us see what is this order. Okay. What has been listed for? Affidavit noted file. You were to file some affidavit?
I am the petitioner. The respondent, they have not filed the affidavit in our reply.
Counsel for the petitioner. Why the office not reflect that you have not yet filed affidavit? What affidavit was to be filed?
My lord, actually today we are supposed to file IA.
Okay.
To bring on record some document.
Have you filed?
We have some document, but one more pertinent document. That order is already passed, but from the municipal authority, that order has not served to us now. By tomorrow or day after tomorrow, it may be served.
You obtain it and file.
Yes, because Your Honor, what has happened? This firm, AR Enterprises, this Kurungkume Enterprises, the respondent firm, the Department of Municipal Corporation, they have already terminated the works. What I have been informed by the petitioner. So
you bring on record then?
May I? Yes. I've got no objection to that. Lord, sir, he had a simple question before this honorable lord, whether the lordship, the 20% interim amount passed by the learned trial court is, whether that is feasible or not. That has to be looked into, Lord. Whether my has been terminated or there is a fake of this, that the trial court will prove, lordship. So the only lordship, this honorable court has to say that, Lord, with this, with this
trial court, the proceeding before the trial court is going on. I think it's proceeding.
Till lordship now, no.
There is no stay.
There was no stay, but lordship.
Why it is not proceeding? You could have mentioned.
Lordship, we have mentioned that particularly on that on last order also, Lordship, since the matter was not taken up, the lower court was assuming that the matter has been stayed. To clarify that, Lordship, we have taken order from this honorable court.
This court also made clear that there is no stay.
Yes, Lordship, for that only that there was an order from this honorable court. Since there is not stay from this honorable court, the matter may be taken up.
Yes.
It has been fixed for complainant witness.
Right.
Lordship, my prayer before this honorable court, since Lordship, negotiable instrument, it says the case has to be disposed of within a month of 6 months, Lordship. Where, Lordship, our case was filed way back in 2023, October 2003.
This was filed in
2023. And Lordship, they had appeared after a bailable warrant issued by this honorable court. Now, Lordship, today is 2025.
This High Court?
No, in the trial court, Lordship.
Before
and in the trial court also, Lordship, the trial court after.
No, this is 24 case, 24.
24, Lordship, I'm saying the trial, Lordship, what I'm saying, Lordship, the trial court after hearing both party, after section 143A of negotiable has given the interim order. Lordship, in their petition also, if I can show you, Lordship, they said the 90% of the work they have been completed and the payment has been done to them. And Lordship, this is not between a 2%, it's between a 2 firm, Lordship. So there is the Lordship the trial court has judiciously taken up the matter and judiciously put his mind and has given this order, Lordship, the 20%, Lordship. Lordship, may I just take you to, I'm not going into the fact of the case because Lordship, that is the work of the trial court. May I take, Lordship? I'll just take you to, Lordship, the page 21 of the petition. Of this.
Your Honor, I am the petitioner herein.
No, see,
I have to have hard first. if my
No,
brother
the
insists, then we
court by
can
an
take up
order
today
dated
also.
16/6/2025 allowed the petitioner to bring on record the documents by way of filing affidavit. Now let him file affidavit, will deal
Lordship,
with the
taking
matter.
time and again, Lordship, that.
Now, why you're taking time again? Thereafter also it was listed again on 6 June.
Yes, my
26
lord,
June.
this document, the petitioner, they were served a show cause notice to furnish the valid registration GST.
See, some stay with regards to the payment of 20% had stay granted to you. So you do not take advantage, the undue advantage of that. So because this is NIA case, so you filed within a week. Okay, you're likely to receive the copy within this week.
Within this week, at least 2 week time may be granted.
Lordship, my understanding for this honorable, whatever the material is there, Lordship, even if some interim amount is passed, Lordship, assuming for a moment, Lordship, in the trial I lose the case, that amount will be repaid back to him with the interest as per the bank interest, Lordship. That is no doubt, Your Honor. Whether the simple question before this honorable court is whether the 20% has been passed as per the paying capacity of the petitioner or not. That is the complaint, Lordship. What is in this matter, Lordship?
That part has been stayed.
That part has been sent. That's what I'm saying, Lordship. Whether filing of that affidavit will not come into taken because whatever material is, we have to go.
Whether this document which
my lord,
you are sought to be brought on record is a relevant document.
Yes,
Relevant to the case.
because my lord, what the the apex honorable court held that
No,
while
forget about the Supreme Court, just whether these is whether these documents are relevant to the case.
Is
So
it-
can this case
it is relevant in
petition
the-
be disposed of without this?
it can be disposed of, but that will
Lordship, that's
be more helpful in this case, in my case, because the entry while
We'll give last opportunity.
while
Lordship,
granting the
just appreciate, Lordship, may I take to page 21 of paragraph 20, Lordship. This is more than sufficient, Lordship. May I take, Lordship? Page 21 of the petition, Lordship.
my lord, if my brother insists, if my brother
No, no,
wants
I'm
the
just
case to be heard today, then I have no objection.
That's all.
Okay.
Since my brother has been insisting again and again in many occasions, because that document is
sought to be
out of-
placed on record is not so important. That means
that is important, but since my brother is in showing so much of urgency, because the document, what the Honorable Supreme Court says, while considering the quantum of interim compensation, the case of the defense has to be taken into consideration. Wherein in this case, my lord, I have stated before the learned court below that there is no prima facie case against for filing the NI case against complaint case.
okay, whatever.
Lordship, may kindly go to page 21, Lordship, paragraph 20, Lordship. Whether they are capable to pay that amount or not, that is the Lordship, the trial court will look into. Lordship, even if this case is passed on my side, Lordship, during the trial, if they prove that they have no case, then that amount I have to pay back him, that Lordship. That is an interim amount, Lordship. 143A was inserted because of Lordship or long pending cases. Lordship, may I take this page 21, paragraph 20, Lordship?
My lord, then will heard the matter today.
This is Lordship.
Today, yeah.
I'll not have it, Lordship.
How long it will take?
I'll take 1 hour to explain the cases.
Lordship, here
then we'll continue it.
Because everything
Lordship,
has
that's
to
what I'm
be.
saying.
Just a minute. So since it's going to take time, we'll take it in the after 2.
Lordship, that's what I'm saying, Lordship. We don't have to go into fake of the case because that is the only the.
He's a petitioner. He's going to take 1 hour.
No.
The
I'll
petitioner,
take 5 minutes. Lordship, that's what I'm saying. Come to paragraph 20.
my lord, even if my brother takes 5 minutes, I will not be taking less than 1 hour because all the case has to be open up.
Afternoon. Okay. At 2. Let us, because other matter, let us try to finish other matter. Yes, and then, just a minute, huh? Then can it be listed, day after tomorrow? Straight away, you come prepared. Yours, okay, day after tomorrow? Okay, it's prayed for by both the Land Council for the parties. Let this matter be listed again day after tomorrow.
I have to subject to my brother because every time he's on busy.
Okay, okay, okay.
My lord, can it be Can it be tomorrow?
Tomorrow list already prepared. Nowadays list is being is limited. Tomorrow list already prepared. Yeah. That's tomorrow. Okay.
Yes, my lord, in this bail application, your lordship, we have received the case diary, but your lordship, this case diary is not complete. Because your lordship, there is an allegation of robbery also. So whether that material has been recovered or not, that are not there, and the statement of the accused is also not there, ma'am. So what my humble prayer would be, your lordship may kindly allow us to produce the complete case diary day after tomorrow.
Okay. Mr. Vijay Jam, Land Council for the petitioner is present. Mr. T. Land Edison PP, some state. He has not received the complete answer in the instant case. The complete case diary would be required for consideration of the matter and place for listing this matter on data tomorrow is on
31.
31. Okay. Prayer allowed. List this matter again on 31.
Deeply obliged.
The
Deeply obliged.
The updated case diary would be produced. Okay.
Deeply obliged, man.
May I please, Your Lordship?
Yes.
In this case, Lordship, this petitioner is challenging the order for which this case was not restored. It was a dismissal order. Now, the interesting point is that, Lordship, this the petitioners filed an application for grant of probate. Now, at the time of granting of probate, Lordship, I'm just giving some history,
just
on the background with regard to
just a minute. Huh?
Yes, Lordship.
This is civil revision. Yes. This was the impugn order is 25.
Yes, Lordship. This last annexure starts from Lordship page number 93. This is the order. Now, just before going to the DP in order lordship, I'm just referring to certain aspect of the matter lordship.
Yes.
What has happened in this case, lordship, when this probate application was pending before the learned trial court lordship, at that point of time, the petitioner filed an application for appointing commissioner so as to cross-examine the attesting witness. He is presently staying in Kolkata and is an aged person. I have annexed the document also, lordship. Now, lordship, kindly see the annexure number 2, page number 27. The learned trial court, page number 27, lordship, annexure 2. The fourth paragraph, lordship, considering the fact. Lordship, got it? Fourth paragraph is the order dated 9/9/2019. Considering the fact and circumstances, I am inclined to allow the prayer of the applicant to pass an order for issuing commission to examine the PW Oshit Ranjan Kaur. Accordingly, the Oath Commissioner of Kolkata High Court is appointed as a court of commission to examine the aforesaid PW with the direction to pay the cost. Now, it is the concerned learned court lordship, the trial court, who had appointed the commissioner, and there was a communication sent to the registry of the Kolkata High Court for appointing the Oath Commissioner. Now, the equal lordship kindly turn to the next page. It's an annexure.
Just a minute, this order was passed
in the year 2019, lordship.
19.
Yes, lordship.
On what application?
Appointing-
Miscellaneous application.
Exactly, lordship.
For what?
Appointing the Oath Commissioner to cross-examine and attesting witness, lordship. Because the petitioner filed an application for the examining the attesting witness who is presently staying at Kolkata, and since he is an aged person, after submitting the evidence, now he is to be cross-examined. So since he is not in a position to come down from Kolkata, so filed an application for appointing Oath Commission, and that has been allowed by the order dated 9/9/2019. This is the order. Kolkata High Court is this direction to the registry of the Kolkata High Court for appointing the Oath Commissioner.
Whether the court here in Arunachal Pradesh can appoint the court commissioner from.
No, lordship, what has happened thereafter? That's why I'm referring to the next page, lordship. The next page on 3/2/2020. 3/2/20. The third paragraph, lordship, pass a reminder to the registrar Calcutta High Court through Honorable Guwahati High Court Itanagar bench, along with this order, an order dated 17/12/2019. So there was a communication sent from the concerned trial court to the registry of this honorable court for communicating to the Calcutta High Court for appointing the Oath Commission. Now it's an administrative process, lordship. So why I'm referring to that, lordship, because subsequently what has happened, the learned trial court, because during that period of time COVID was there, so I was not in a position to conduct the case.
No, my query.
Yes, lordship.
Just query. The court here in Arunachal Pradesh.
Yes, lordship. Court can appoint a Oath Commissioner, lordship.
Straight away, the Oath Commissioner as.
Yes, lordship. These are all advocates, lordship.
No, because.
They are all advocates, lordship, Oath Commissioner.
They are advocates.
Advocates, lordship.
Okay.
Just like in Guwahati also, there are Oath Commissioner, are all advocates, lordship. But the appointing the Oath Commissioner, the instruction of the direction of the registry of the concerned court is required. So accordingly, the communication.
That is why I'm saying, register of the concerned court. That is why I'm saying.
That's why communication.
Okay, anyway, because now it's already one. So.
At this stage, notice may be issued, lordship.
Notice, will issue notice only.
Yes, lordship.
Mr.
SP Chaudhary, lordship.
SP Chaudhary, I'm a counsel for the petitioner. The petitioner filed this application under Article 227 of the Constitution of India. Challenging the order dated 23.
Yes, lordship.
4/2025. 23, which one is 23 page?
Lordship, page number 92.
What is this order?
I'm just Page number 93, Lordship.
What is
Annexure 15.
What is this order?
This order means, Lordship, after the dismissal of that particular probate case, I filed an application for restoration, and that prayer was not taken into account.
So by this order, they dismiss your application for condonation of delay.
Condonation of delay.
Yes,
Now,
ma'am.
what has happened in this case, Lordship? That's why I'm referring to other orders.
It's
Lordship.
1035 days.
Yes, Lordship, but this is with regard to substitution, because without restoration of the case,
Passed,
because
okay,
Yes.
23/4/2025, passed by the High Court of District Judge Boundila, West Kamen District in IA number 09/2024, arising out of probate case number 01/2018. Whereby the condonation application filed by the petitioner for substitution of the legal heir
yes, Lord.
of the original defendant has been rejected. As well also for a restoration.
Lordship, that was actually for restoration, but the learned trial court rejected the prayer for this one, substitution, because without restoration, substitution cannot be allowed.
Yeah.
So restoration was not done, but substitution was rejected. It is the
Okay, whether the restoration petition was
no order was passed in the restoration petition, Lordship.
no, but then without condonation against.
Condonation with regard to substitution.
Okay.
And no order was passed in the restoration application. So that is the reason why I filed this civil
So
revision.
let us see your prayer.
Which one, Lordship? In
Your
the-
prayer.
in this revision petition?
Yeah, yes.
Yes, Lordship. Page number 20, Lordship.
20.
Hmm.
Okay.
In 21, I made a mention for restoring the probate case number 1 of 2018 to its file. Page number 21.
For condonation of delay in
Yes.
substituting the legal heirs
Legal
of the original defendant.
Because first of all, the court is to pass an order with regard to restoration of the case. Then only the substitution would come. In the substitution also, there was no objection on the part of the legal heirs of the defendant. The learned trial court rejected that prayer, and there was no order passed in the substitution petition.
But then for the moment you are challenging this order only.
Lordship.
Okay.
Since there is no other order, Lordship, so I have to challenge this order only. That's why I made a mention for restoration of the probate case, Lordship.
Whether record
Record is required, Lordship.
is required.
Yes,
Okay.
Lordship.
Call for the record. Call for the file for record. Issue notice. The petitioner shall take steps upon the respondents by a registered post with AD, as well as by usual process within a week from today. Stop. This matter after 4 weeks.
Can a date be fixed, Lordship, since I'm
Okay.
coming?
When do you want? Then it will
In
be
the month of
after 6 weeks.
6 in the month of September, Lordship.
Okay, September.
First
give-
week of
give
September.
date.
It is possible in that.
Is prayed for come at least this matter
On 2nd of September, it
on
was
2/9/2025.
2/9.